Welcome to Crestview Community TV's Court TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today we're watching a miscellaneous court date / VOP court date. You're going to see, by VOP we mean violation of probation, and you're going to see a lot of people this morning who are, a lot of them are going to be incarcerated because they've violated their probation. When you violate your probation, you're not entitled to a bond. Doesn't mean you can't get one, it means it's harder to get one. On a new law violation, most people are entitled to a bond, absent some major circumstances. When you violate that probation, though, you're not entitled to a bond, but you can get one. But that leads this court date to having a lot more inmates. Now, when you're called to the podium, a couple things you can do. You can enter a plea to your VOP and say, yes, I did it, I violated my probation. And you can get sentenced. You can ask for a continuance. Let's set this down the road, maybe try to work out some details, maybe try to work out a deal. Or you can ask for a contested VOP hearing, which will be set at a later date in one of the afternoons of this miscellaneous date. Now, VOP hearings are very hard to win. It's a different standard of proof. We don't see a lot of them because it's rather easy for the state to prove if you violated your probation or not. So you're not going to see a lot of contested VOP hearings. Now, in addition to the violations of probation in the mornings, you're going to see some other smaller, shorter hearings, things like bond hearings, or things that don't take a lot of time, normally 15 minutes or less on these morning hearings. Anything longer than that is going to be set to the afternoon.
Look for it.
Court is now in session. The Honorable Judge Karen Ketchum presiding.
I believe that's what were you saying? I thought you were saying something. Oh, okay.
That's probably talking to you, Taylor.
I'm not willing to make a non-incarcerated offer today on that case. See this? Says who? Says you? I would be interested. But let me send that to our prosecutor.
Morning, Judge. Tim Shaw for Nathaniel Fannin, case number 23 CF 1505. I'm sorry. No problem. Fannin, F-A-N-N. Judge, we filed a motion to modify terms of pretrial release.
Court has reviewed that.
Okay. I have my client's father here who can testify as to the factual basis, but, I'd proffer what's in the motion. I've spoken with the state with regard to our request to modify that provision. The state indicated that if they had been able to get in touch with the alleged victim in the case, that they would potentially stipulate to it. However, they've been unable to contact her.
That's correct, Judge. Essentially here, the defense has proffered to the state and said that the victim no longer lives at this residence. That's the crux of the motion. Here, the state has reached out to the victim numerous times. I've even emailed her. Her inbox I was unable to leave voicemails because it was so full, I believe, and her email is so full that it boomerangs back, leaving me with no way of contacting her. I can't stipulate because I don't know if she's still at that address. I understand that it's a very difficult situation for the defense, but the state can't stipulate.
I'm going to take his stipulation as fact unless you tell me you want me to put him under oath. Are you willing to stipulate to the facts based on what? Let's put him under oath. Would you raise your right hand? Who do you want it?
I'd prefer his father to testify. Doug?
Put him in the witness. Come on up here so you can. Madam Clerk, for the witness. Raise your right hand, sir.
Do you swear or affirm that the testimony about you will be the truth, the whole truth, and nothing but the truth?
Please be seated, counsel. You got to pull, you got to talk right. It's very direct. It's a very directional mic. Go ahead, Mr. Shaw.
State your full name, please, sir.
My name is Robert Douglas Fannin III.
Okay, Mr. Fannin, what's your relationship to my client?
I am his father.
Okay, and the home that we're talking about, the residence that we're talking about, whose name is that residence titled in?
It's in Nathan's name, my name, and my wife's name. Our
Okay.
three names together.
All right. Since July of 2023, when this event occurred, your son's been out of the home, is that right?
That is correct.
And has stayed out of the home in accordance with his pretrial release conditions, is that right?
And he hasn't gone near it.
All right. But you have, is that right?
That is correct.
Describe what you've seen when you've been to the residence.
Well, after we were wondering where Ms. Taylor was, we went over there just to check the condition of the house. And the house was completely trashed. In fact, we had problems going into it because it was full of fleas. We couldn't walk out without being covered in fleas.
Was she there?
No.
Okay. Do you recall approximately when that was that you went over to the home?
It was late September, early October timeframe.
Okay. And since that time, have you gone back by the home?
We've been back generally weekly for no other reason to check the mail, but we've been trying to clean the home, get rid of the fleas, that sort of thing.
All right. Has Ms. Taylor Anderson been there?
Not at all. We have not seen or heard of her since last July.
Counsel, I've heard you.
Okay.
You may sit down, sir. You want to come across?
No, Judge. Thank you.
Sorry.
No. That's fine, Judge. Thank you.
Court will grant your motion to modify the terms of the pretrial release. You can get me an order to as far as the specific. And what we're really doing is just allowing the defendant to have access to the home.
Yeah, he can go back to that. Great.
Okay.
Thank you, Judge.
Thank you.
I'll send it over.
Thank you, Judge.
Thank you very much. I have Mr. Flowers being on here, but Mr. Notes?
I've got Roselle Payton for a bond hearing.
Okay.
Judge, as my motion states, Mr. Payton has no prior failure to appears. He's been a resident of Okaloosa County his entire life. The bond set at first appearance was $250,000. Judge, he's simply not in a position that he can do that financially. He can't afford that. The assessment that was done by pretrial prior to the first appearance said that, you know, as far as the score that they used, it was a low to moderate range. It also states that he has no prior failure to appears. We'd ask the court to try to set him a bond that he could afford, maybe a $1,000 bond, maybe if not that, then maybe $3,000 or $4,000 bond, but that's just $250,000 he just can't make.
Your Honor, Mr. Payton is charged with trafficking in fentanyl. His lowest permissible prison sentence is 47.10. However, this is going to be a 7-year minimum mandatory. Your Honor, the state would object to his bond being reduced.
Anything final?
Judge, there were 2 other co-defendants that were also arrested at the same time, so I understand the state's position that what the charge is, but you know, I don't clearly think that any of them had actual possession of anything. So it changes somewhat the position of being the strongest case in the world.
Well, but we're not here really arguing over the strength of the case. I mean, you can argue it if you want, but I don't think that's one of the criteria. Has there been something that's changed since the bond hearing?
Judge, I got appointed on the case on January 5th. It was, I think the bond was set at first appearance.
Well, based upon the fact that there have been no actual changes, merit bond modification, and the fact that these are very extremely serious charges, and I assume the state's seriousness of the charges affects the safety of the community. I understand it's a very large bond that the court's going to maintain.
Okay.
Thank you.
So,
Trafficking of fentanyl is one of the most serious charges we've got.
Judge, I understand that, but I guess, am I hearing that if a bond is set at first appearance, then unless there's been some substantial change or something?
I think as a general rule, you know, that is a factor that the court will consider if there's been a change in circumstances. And, you know, unless maybe what's been done at the first appearance was improper. I'm not hearing improper. I'm just hearing, I assume that same argument was made at the bond hearing. That, hey, I can't afford that. He's not going to be able to. That's not an uncommon.
Well, Judge, the purpose for the bond is that he.
Well, there's 2 purposes. There's bringing back to court, safety of the community. Well, everyone, defense, all due respect, defense often focuses on the ability to pay, understandably, but there's this other factor. And in this case, I see why the bond was put in. Would I have done 250? I don't know. Might have done 150, 100. Right? It would have been substantial, but that's not. When we come here, it's not just say, well, what does Ketchel want? What's the new judge? It's whether or not there's been a change in circumstance is a significant factor. So that's the answer.
Your Honor, can I say something?
Go ahead.
I have 5 different codes.
Raise your right hand. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir. Well, Your Honor, I have 5 different co-defendants, and the rest of their bonds are $50,000, and one of them have a 40,000 bond on the charge.
Maybe
And I'm
the
the
state
only,
needs to bring those charges up here and get a higher bond, I don't know. I'm only dealing with your bond.
in my bond,
Okay.
for that
I'm not
one charge.
arguing with you, counsel. I appreciate you making an argument. You got found probable cause on a very serious charge that has significant minimum mandatories, and there's an issue of safety to the community.
Judge, may we approach briefly, because there's something on the first appearance sheet that I don't understand what it says, the handwriting.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Thank you very much.
Thank you, Judge.
Is that your only case, Mr. Rhodes?
Judge, I've got a case this afternoon, but I don't believe he's here yet.
Okay.
Does this court allow any Zoom appearance?
I'm not saying I never allow it, but as a general rule, we're trying to go live. That's our first.
I understand, Judge. The only reason I ask is that the hearing will probably take less than what this hearing took for a bond hearing, and I'm going to go back to Crestview and work, and then I'm trying to come back, and then it's a bad time of the day to be on the road going back to Crestview.
Well, if he'll be here this morning, we'll take it this morning.
I don't think they can get him here, but
Oh, is
He was set for this afternoon, Your Honor, so I think the transport officers probably don't anticipate him coming until this
that's
afternoon.
fine, Judge. I'll be back.
Okay. Okay, we'll just,
Hey, Marty? Hey, Judge, can we bring Mr. next second? Mr. Medina just made a good point.
Marty?
I was trying to help him.
Yes, that'd be great.
Yeah.
Judge, so I appreciate everybody, we actually all like one another, and we're always trying to help one another. They suggested if I just went to the jail and we could appear via video for the bond hearing from the jail, I'd be standing with my client.
That'd be fine.
Yeah, so can we, Judge, we'd have to let the transport officers know that it's Ashby, right?
No, Mr. Cooper.
Cooper, I'm sorry. We let the transport officers know Mr. Cooper doesn't need to be transported.
I'll email the folks that I get, puts on the list.
I've got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
A number of defendants here that are without an attorney. You want to try and go ahead and do those?
Yes, sure.
Since we don't have any defense counsel anyway. So let me make a general statement for those of you all who are here without an attorney. This is a miscellaneous docket, and one of the things that we handle on the morning of the miscellaneous dockets are basically the violations of probation. So this is similar to like an arraignment where you're coming to make an initial plea if you had a regular case. But this is a violation of probation, which is technically, not technically, is a new case, okay? And so when you come forward, in this case, I see that you haven't had an attorney, if my records are correct in front of me here today. I'm going to ask you whether you want an attorney. So I'm going to do two things. One, I ask you whether you want an attorney. If you say you want one, I'm going to go ahead and appoint an attorney, or if you tell me I'm going to get a private attorney, you can, that's fine too. But then we'll go ahead and enter basically a plea, basically enter a denial on your behalf, which will preserve your rights, so you can meet with your attorney and we'll set up a hearing to come back. So I'm telling you all this so I don't have to repeat it every time somebody walks up to the podium. So let me go ahead and begin with Tevin Austin. Tevin Austin here. Okay, I'm going to be asking the state to verify that he had so much trouble with service that he was served. If he was served, then I'm anticipating some mistake wishing or something.
Yes, Your Honor, give me. Because it was misdemeanors, Your Honor, so I do believe that he signed a notice to appear, but give me, I don't want to speak out of turn. No.
I would appreciate it.
Because Judicial Correction Service usually does have them sign something stating that they need to be.
Clerk wants to jump in. You can find it faster.
He was arrested and we sent notice to his address when it was not going to be turned.
And it was for today?
It was for today.
You did receive notice through the mail?
Yes,
What's the
Your
state one?
Your Honor, the state's asking for a capias.
Court order or no bond capias. Next is Robert Barkley. Barkley, you just come up to the podium here. Would the state announce the cases?
Yes, Your Honor, so this is 20 CF 215 and 21 CF 1344.
As I mentioned, Mr. Barkley, you do have a right with these violations of probation to have an attorney appointed. You wish to have an attorney appointed?
Yes, sir. I like a public defender. I don't know why they didn't assign me one yet.
Okay. Well, court will appoint the public defender. We will come back. So where are we at on our March 14th and 19th? March 14th is just the numbers. I'll make sure about what I want you to go look for that. We're going to come back on March 14th.
Yes, sir.
9 a.m. Thank you very much. Look up and see what we have for 19.
I'm appointing the public defender, so I need you to speak to the public defender now. You have an attorney, I'm sorry.
Okay, next is Joshua Boudreau. Same question regarding service. Normally I would assume service, but we've had so many problems.
And again, Your Honor, this is a misdemeanor situation, so let me see if I...
Notice was sent, but it was returned.
It was returned undeliverable, Your Honor.
And so what do we need to do?
I would ask for this to come back next week, but I don't know if that's enough time for it to be sent back, a notice to be sent again. I don't.
I don't think we sent back to return. This return thing's gonna get through it. I mean, is this a problem? I mean, if it was sent and returned, he gave the address, didn't he?
Yeah, Your Honor, he's supposed to be on probation, and he's supposed to report his address. The only thing I know to do is to make sure that address matches with what's on probation, but that's the only solution I can come up with.
You asking for capias?
Yes, Your Honor.
Court will order no bond capias. Ms. Dudley, you want to come on up?
Okay, one second, Your Honor.
Okay, we've got a few others. Robert Brazil. Approach good. To the state announced.
Yes, Your Honor. So this is 21 CF 3134, and Mr. Brazil also has 22 CF 2555.
Is that also a violation of probation? That's not on my docket.
Yes, Your Honor, I do believe they're both violations of probation. And I do think that the new charge is with the public defender, if I'm not mistaken.
So you might want to just check 2555. We'll deal with both of them. Sir, as I said, do you have a right to have an attorney on these new violations of probation? Do you wish to have an attorney appointed? You're going to hire private counsel. Public defender?
Yes, but also I'm a little confused. This is only one violation of probation that I'm understood.
Well, today, what I've got is a violation of probation. Ms. Sharpless,
It's one violation and two different case numbers, Your Honor. So it's one violation, but there were two different cases he was on probation for.
Okay. That's your answer.
Yes, sir. Those two cases were run concurrent. One of those cases.
They're running concurrent, that's right. But they're just technically, just go over it with your attorney. I mean, we're not trying to double it.
Your Honor, the 23 CF 2507 case, which is the new law charge which triggered this violation, is with Mr. Medina.
Okay. Very good. So we'll continue this. We'll appoint the public defender and continue this to March 14th at 9 a.m. Just meet up with your attorney and try and go over and figure out what exactly is going on.
Yes, sir.
Okay?
Judge, the 23 case is set for pretrial conference on March 8th. I don't know if we wanted the BOPs to track with the new law charge.
What's that?
It's up for April, not March.
April, I said March, thank you.
Okay, so we'll do the March 14th on the BOPs. March 14th at 9 a.m. Okay?
Thank you.
Ms. Dudley, you want to do yours?
I can talk to Sharpless real quick.
Okay, well, I'm got to keep going here then. Coco Carthen?
Well, Judge, could you maybe call one of my...
Which ones? I don't know which ones are yours.
I think...
That's why I've got the defense counsel on my list and not the...
Yes, Judge. How about Stephen Hull?
Stephen Hull?
Hull.
Very good. Stephen Hull.
And I think this defendant was a different case.
I'm sorry.
She came to the podium when you called the last case, This isn't Stephen Hull.
I'm Coco Clark.
Okay. Ma'am, hold on a second. We're gonna jump over this in just a second, so stay with us. Is Stephen Hull here?
And I'm checking Benchmark to see if he received notice.
Thank you. He's what? He's an inmate. He's an inmate?
Okay.
Is he here? I apologize. All right, he was on my list, I didn't even see it. May 21. When he comes in, I'll ask you just to announce the case number.
Yes, Your Honor.
Correct.
Your Honor, this is case number 2021 CF 000-905 and 2021 CF 001871. The defendant is...
The second number is not the one I have.
Sorry, 1871.
I have 21 CF 2665.
That's not the number that's on my docket, Your Honor.
Give me your number again.
It's 2021 CF 001871. The defendant is charged with 2 violations of probation. This is an incarcerated DOC offer.
Figure out what the case was.
Are you looking up Stephen Hull, H-U-L-L?
Okay, there we go, we got those two. Okay, on these 2 new charges, sir, they are new charges. You do have a right to have an attorney appointment. Okay?
Yes, sir.
Do you wish to have an attorney appointment for these?
Sir, if it's any way possible, I don't want to waste your time and the court's time. If the state has an offer, I'd like to see what their offer is today.
Okay, you may not have heard what he just said. He said their offer is incarcerated. So you probably want to meet with your attorney.
Can I ask
The
you
offer
what?
they're going to do would be result in incarceration. You probably want to talk to your attorney about it.
I don't have an attorney right now, Your Honor. That's just
I'm
not.
going to appoint an attorney if you want one. You don't want one?
I would like to, if I can, go pro se, sir.
What's your offer?
Give me a second, Judge.
Your Honor, also,
No.
yes, sir.
Judge, I'll have to look at the score sheet. Usually when it's incarcerative, he gets appointed at counsel, so I didn't write the offer on my docket.
Okay, well, you don't have to have an offer today, but if you have one.
I don't have one offhand. I do
They don't
know
have their offer ready.
it's going to be a DOC offer.
So, you're here on a plea, if you wish to represent yourself.
Can I make an offer to the state, Your Honor?
No. This is premature. They haven't been able to evaluate it. If they had evaluated it, they would have made you an offer. So they'll give you an offer, but it's just not today. You do have to make a plea, either admit or deny. I assume you wish to make a denial, and we'll come back and let the state do their calculation, and you can have a discussion about that. Is that what you want to do here today?
Well, Your Honor, I mean, as far as, I'm trying to get it over. This is from 2021, sir. I'm having no luck with the public defender's office. Them contacting me and representing me. I don't even know who I have to represent me.
Do you wish to admit or deny these new charges? That's what we're here.
What are the charges, Your Honor? Can I hear what the charges are, sir?
On your behalf, reserve your rights. These are 2 violations of probation. Do you have any? Go ahead.
I just would like to know what the violations are, sir. That's all I'm asking.
Okay. You'll be providing, counsel, can you provide him copies of the violations of probation?
Certainly, Judge, if he files for discovery, the state would be happy to send them over.
Very good.
So he
That's
would
why
just...
you want an attorney, so they can...
Okay, will you
get
appoint the
these.
public defender's office then, sir?
Okay. Court will appoint the public defender, will enter a denial, and we'll come back on 3/14 at 9 a.m. Thank you very much.
Thank you, Judge.
All right, I'm ready.
Ms. Dudley?
Your Honor, first one I have is Malik Coward in 23 CF 2274. We were set today for a motion to compel discovery. The state has sent over the offense report and an e.com link. When I reviewed it last night, while it is some of the evidence, it's not the body cameras, photos from the actual incident. It appears to be 2 body cameras and photos from a search of the home. However, Mr. Coward is charged with items from a traffic stop. The report talks about search warrants, that they have body cameras, and we don't have any of that information. So that's the stuff we're still missing in this case, as well as lab reports that are mentioned throughout the report. So those are the items that we still need.
And Your Honor, I did have to request the body camera, and I just got it yesterday. The evidence.com is not working how it usually works, so it took a little bit to get that. I will get with the sheriff's office, and I have Miss Dudley's list of stuff that she doesn't have, and I will get that to her if we want to.
How long do you need?
I mean, I would say at least a week, Your Honor. I don't.
Okay, the court will give you 10 days. Court will grant your motion to compel. Give the state 10 days to provide the remainder of the information.
Yes, sir.
Discovery.
Yes, sir.
Okay, if you'll give me an order, we'll get it signed.
Yes, sir. I'll get an order today.
Thank you.
And our next case I have is Tyrese Davis in 23 CF 2273. His appearance is waived. This is the same issue as Mr. Coward. They're co-defendants somewhere. Same arrest, same offense report, so it's the same items that are still missing.
Okay. I thought today's hearing was on the motion to modify the pre.
I have two motions, Your Honor.
Okay. I didn't see the other one being set, but I may have missed it.
Yes, sir.
So what's the state's same position regarding the
It's the same.
motion to compel?
That's fine.
Okay, so I'll grant the motion to compel and provide 10 days.
Yes, sir.
10 days to provide the additional discovery.
Your Honor, motion to modify, the state has agreed to modify the GPS to $1 a day and to remove the house arrest. So I will submit an order today to the court.
Very good.
And I believe that is all I have today.
Thank you, Ms. Dudley.
Thank you, Your Honor.
Mr. Flowers.
Judge, there had been set a motion on Carson Honeycutt, and I think I announced to the court a couple of days ago that wouldn't be necessary today. We're working on those matters out of an abundance of caution. I wanted to make sure.
Find the case.
Yes, sir. I don't think it's going to be on your docket, Judge.
So,
what I did, Judge, 2 days ago I was before this court and announced that today's hearing wouldn't be required. The state and I are working to work out a solution to a motion hearing.
okay.
And so, out of an abundance of caution, I didn't want to be called in case it was still on your docket. And I'm just here to let the court know that.
Well, I appreciate that. And,
Yes, sir.
But I didn't see a case when I was going through it where your name was on it.
Yeah, thank you.
Okay.
That's all I had, though, but thank you, Judge.
Thank you, Mr. Clark.
Thank you.
Okay.
Judge, another unrepresented that you might call is number 13 on the docket, Shamal Roach.
Very good. Mr. Roach? Same question. Was he provided notice?
I'm checking right now. Is he an inmate?
is not an inmate.
Okay.
Thank you for asking. We missed that. That was me. I was right on my, I just didn't see it. I didn't hear it.
It looks like a notice to appear was sent out on 1/19, if the clerk can confirm that.
For today?
I'm looking, Judge, one moment.
He appeared in court on January 16th and was notified of the court date today.
That's correct, and also it was on the notice to appear for today.
State?
I would request a KPS.
Order KPS, no bond. I've got just a couple. Others, Chapman and Graham, who's handling that on the state thing?
Your Honor, Mr. Chapman is mine. I think Mr. Graham's might be Mr. Velasco's.
I can handle Graham.
Okay, Graham's an inmate.
Right. Davion Gray was not transported. The court appointed me yesterday to his case, and we set him for Monday to get Keaton, and he actually was approved for Keaton, so we'll be handling that on Monday.
Okay. Very good. So
Cancel that one, please.
All right. Okay. What about John Chapman? Who's handling that?
That's Mr. Medina. That's going to be a competency issue.
And I think Mr. Medina had asked specifically for him not to be transported today as well.
Mr. Chapman?
Yeah.
I didn't have him as an inmate, but that's
I had him.
He's in a
He was transported? Let's try and get him as soon as. We'll wait for Mr. Medina to come back.
Dixon.
We also have Coastal Carthamon who passed the first.
Cartland, that's right. Who's handling Ms. Cartland state?
Your Honor.
Does she have the public defender yet?
I don't have her as being appointed a public defender, but if.
Once she's appointed, it'll be Ms. Farkas.
Ms. Cartland, can you come forward? Who's handling this for the state?
That's mine.
Did you announce the cases?
Yes, Your Honor. So this is 21 CF 2665 and 23 CF 905. Your Honor, these are two violations of probation.
So, Ms. Carthen, as I said before, you do have a right to an attorney with these new charges. You wish to have an attorney appointed?
Yes, sir.
Okay. So the court will appoint the public defender. She's actually right there. She's going to give you a card for you to get together with her. The court's going to enter a denial on your behalf to preserve your rights. And we'll come back on March 14th at 9 a.m.
Okay. Thank you.
Thank you very much.
Ms. Farkas.
You want to start with Ms. Farkas's or Mr. Medina?
I need to talk to a few inmates, Your Honor, so maybe one of my colleagues.
Ms. Farkas, you want to start doing your case, or do you want me to go with Mr. Gates?
Are you ready?
Ready to go. Let's go, Mr. Gates. Hold on a second, I'll tee him up for you.
Steve, I brought 33 through 37.
Yep. Correct. My first one I have is Jonathan Freeman, 45.
Your Honor, I have one that's got a medical issue. Could I call her first?
Sure.
It's just a medical. She's 3 months pregnant, so I don't want to.
That's fine. What's
the name?
What's the name?
Your Honor, Haley L. Bernard. I apologize.
That's all right.
That's okay. Can you stand for a minute? Okay. Your Honor, Haley L. Bernard. I don't have the docket number. I'm sorry for the VOP calendar at 9 a.m.
It is 22 CF 2083.
Yes, Your Honor. Ms. Bernard got a continuance on December 14 so she could work on her substance abuse treatment classes. She has completed, she represents to me 3 of the classes. They're $40 a class. They've cut back on her hours at Waffle House. She has apparently 4 classes remaining. I'm asking for one, hopefully the one last continuance so she complete her classes.
So would March 14th be sufficient time, March 19th or April?
I think April would be better.
That's fine. We want to give you an opportunity to get that done. That's the key thing is.
Hopefully the hours are going to increase, but her pregnancy is going to increase. So.
Sure. April 11th at 9 a.m. Is that okay?
Yes, sir. Thank you.
Thank you very much.
All right. For those classes, knock it out.
April 11th?
Yes, ma'am. You want me to write it down?
Yeah, write it down for
Thank you.
Yes, ma'am. Thank you.
Thank you, Mr. Gates. You're welcome. Okay. Jonathan Friedman.
I know.
I know Mr. Freeman quite well. Your Honor, this is Mr. Jonathan Freeman before the court, 23 CF 2554. We do have a plea agreement. Your Honor, Mr. Freeman will be able to plead no contest as charged. The score sheet does show, I want to say 18 months DOC. The state has agreed to the probation offer in lieu of DOC, Your Honor.
What number is this on the docket?
It was an add-on.
25 is what I have. Jonathan Freeman. There were some add-ons late over the last, like literally yesterday there were several. That was totally my fault. But they reprinted, the clerk was nice enough to reprint.
Yes, Your
Not
Honor.
reprint, but to redo the document, so it may have been added, it may not be on your list.
And this was one I felt realized was not being transported for court.
This is Jessica's case, right? Yeah. Give me 1 second.
And Your Honor, while the state's reviewing, I do want to ask the court if Mr. Freeman can have 24 hours to report to probation. He's going to have to try and arrange a ride, and I want to make sure he gets plenty of time to have that done before he.
So can you do it in the morning, first thing, tomorrow morning?
I don't know how I'm going to be able to do this because of my, I don't know what the probation office is for.
We're going to give an address, Your Honor. When I had him originally, it was in Shalimar, so he knew where it was at. Probation's going to give him a map with the address to make sure he can get there.
Probation has the address right here, and I have the address right here. He needs to report immediately upon release. It's not that far from here.
Your Honor, the issue is Mr. Freeman's got an intellectual disability, and I'm trying to take that into consideration by ensuring that he doesn't get violated because some sort of issue beyond his control and can't get there immediately. That's why.
Are you going to try and get there today?
Yeah,
He's.
I don't know everything yet. I never.
Okay, well, the probation officer is here, and he can help you to tell, give you directions and things like that. He'll meet before you leave today.
Okay.
He'll help you give direction, things like that. Okay.
And can I ask a question?
Well, wait. Yes, you can, but I want your attorney to be able to hear you. Yes. What is your question?
Now, I've been off my medication in the jail, all my bipolar medicine, all my depression medicine, and I've not been taking that bipolar medicine. I've been going off, do stuff. Yesterday, I lashed out on an officer on a CI by accident because I cussed her out because I got angry. And I was walking around and I was just trying to get myself calmed down where I can settle down and go to sleep at night.
I understand that. Do you have the medication where you'd be able to go back on your medication? I know it.
I do, but not my depression medicine. Not my depression. My depression medicine, I can't be taking it no more because of my seizures I have.
Is there a question?
Your Honor, I'm just going to say, I think the court can kind of see the reason I was asking for a little bit of time for Mr. Freeman. This is not a usual situation. And just so the court's aware, I did get an eval done. I've always done on Mr. Freeman. He came back competent to proceed. The state took all this in consideration. Instead of seeking a DOC sentence, they were willing to consider probation to give him an option.
Here's what I'm going to do. So, Mr. Freeman, when you get out today,
yes, sir.
It's your obligation to try and get to the probation office.
Okay.
If there's some issues on probation, you've got to do what you got to do. But I'm going to be reminded of this. We just have to take the situation into account. I'm trusting that you all are, yes, sir, going to give appropriate consideration based on his medical condition. Sir, I'm comfortable you will. Yes, so we'll just say, as soon as you get out, you got to go there and you know, do your best. And it might want to be a situation where you get a phone if he's having trouble. Give him a phone number and he can call. You guys do this a lot more than I do.
And I know I didn't got a phone because my phone got cut off too.
Okay.
And Your Honor, Mr. Freeman and I did have a conversation. I read the plea agreement to him before he came out. He has done probation before, so I know he knows the general conditions. So this is another reason why I was comfortable doing this today as well.
Thank you. Thank you.
And Your Honor, this is Ms. Jardina's case I'm covering, but she did want the court to know that this is a downward departure, but it's a negotiated and coerced.
Very good. Would you announce the plea agreement, Mr. Davis?
Yes, Your Honor. Mr. Freeman will be entering a plea of no contest as charged. Be adjudicated guilty, placed on 3 years of probation. We're going to waive the cost of supervision, $967 of court costs, $150 public defender fee, required to do an anger management course, obtain a mental health evaluation and any recommended treatment, stay on his medication if prescribed, and no contact with Mr. Kenneth Mitchell Lowry Jr.
Okay. Mr. Freeman, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay. So you heard your attorney state the terms of your plea agreement?
Yes, sir.
And I see that those same terms are written down and you've signed that. And I just want to make sure, have you gone over this in detail with your attorney?
Yes, sir.
And you understand what you're doing and what the requirements are under
yes,
the probation?
Yes, sir.
So, and the big part of it is you've got 36 months of probation, and there's some fees and costs, but you got to take, some anger management and mental health evaluation, some of those things. Probation will help direct you on that, so you need to, work closely with your probation. That's the one thing I'm going to say to you. You make good contact with your probation officer so you're in good contact, okay?
Yes, sir.
So if you have a question, you can pick up the phone and call them, or use somebody else's phone, okay? You got to stay in good contact. It's going to be key to this because we want you to be successful.
Yes, sir.
I think you want to be successful.
Yes, sir, I do.
But one of the things we have to do is get you to this place where you can get back on your meds and where you're comfortable with that. And you've got some people that'll work with you. Okay?
Okay.
So do you have any questions? You understand this will be a final resolution of your case?
Yes, sir.
Good, because it's probation. You're not going to have any further jail time on
yes,
you.
Sir. I
So as long as you abide by all this.
Yes, sir,
okay?
I will.
Okay. Do you have any questions about what we're doing here?
No, sir.
Okay. Based upon Mr. Freeman's testimony, the court will there'll be an adjudication of guilt with 36 months probation, waive the cost of supervision. There's some fees and costs. They'll go over that with you. and you've got an anger management course, mental health evaluation. One thing, this, I don't know, this Mr. Lowry, you have no contact with Mr. Lowry, right? With Kenneth Mountain Lowry.
Yes, sir.
Even if he comes up to you, walks up to you, you gotta walk away from him.
Yes, sir.
Okay, if he walks up to you, he can do what he wants to do, but you gotta stay away from it. You're.
I know.
Okay?
I don't want to do with him anyways.
Okay. Any questions?
No, sir.
Okay, good luck.
Thank you.
Mr. Frank, were you gonna give me a score sheet?
I will, Your Honor. I can print it out for the court, and I'm going to show Mr. Gates the one that I have.
Thank you, Your Honor.
And
Brian Guillory. Yes, Your Honor, this is Mr. Guillory. My docket's old, so I will let the court, I think we're going to go in order at this point.
yes, that's good.
At this time, Your Honor, we're going to enter a denial in Mr. Guillory's case, 19 CF 941. I do want to let the court know he does have two new cases, 24 CF 157 and 24 CF 158, that are scheduled for next Tuesday for arraignment. This time, if we can enter a not guilty plea on those as well. I think everything is scheduled for April the 10th. So if we can move it all to that date, Your Honor.
What's on April 10th?
That would be felon or his pretrial conference.
Very good. So we'll, on 24 CF 157 and 158, those are the two new cases.
Yes, Your Honor.
Court will enter a not guilty plea. And on this case before us today, which is the 941 case, the violation, court will enter a denial. We'll come back on a regular pretrial. We'll track all these together. We'll come back on April 10th at 9 a.m.
Thank you, Your Honor.
Jonathan Holcomb.
Your Honor, this is Mr. Jonathan Holcomb before the court in 23 CF 355 and 24 CF 477. If we can continue his VOPs without subpoenas, Your Honor. He was recently picked up on a new misdemeanor, so I want to try and work that a little bit and see if we can't get a resolution worked out for Mr. Holcomb.
So
March
14th.
That'll be perfect, Your Honor.
Court will continue this until March 14th at 9 a.m. without subpoenas.
Your Honor, this is Freddie Huff before the court, 20 CF 2842, 21 CF 285, 21 CF 1001, and 22 CF 2835. I've been in communication.
What's the first number that you gave?
I have 20 CF 2482.
Okay, very good.
I've been in communication with his probation officer, Officer Morales. She's recommended UC, but she and I talked about a treatment option for Mr. Huff. She's actually recommended drug court. He's in the process of being screened for that program. If we can continue him to the March 14th date, my hope is that if he is approved and accepted, he'll be off our docket by then.
Okay. Court will continue this till 3/14. Hopefully that will work out good. Drug court is a very good program. Hope you gotta work it, but it's a very good program. Okay, we'll continue this until March 14th, 9 a.m.
Next up, John's.
Your Honor, this is going to be Mr. Austin Johns before the court in 22 CF 2077. They're speaking with the state. If we can bring Mr. Johns back on Tuesday, I've given a counter offer. The state wants time to review it before making a decision on that.
That's correct, Judge.
So next Tuesday is 20th, right?
Yes, Your Honor. At 9 a.m. miscellaneous.
Come back on February 20th, 9 a.m.
Thank you, Your Honor. Eric.
What are our numbers looking like?
Your Honor, this is Ms. Klosterman before the court in 23 CF 909. I intended to bring her back Tuesday based upon my conversation with the state. Ms. Klosterman reminded me again. I went back and looked, and for some odd reason, the probation violation says 6 months of probation. However, she was sentenced to a year of probation. So,
sorry, say that again?
She had 2 counts before the court. She pled to 6 months probation in count 1, a year of probation in count 2. The way I'm looking at it is it looks like probation violated her prematurely because she had a full year to do all the obligations.
Hold on.
Excuse me, sorry.
And normally I would have announced that the terms could have rolled over after the 6 months to give her the full year to do that if we ended up with an issue.
What is the violation? Is it payment or classes or?
Classes. It was all of that, Your Honor. Long story short, Miss Klosterman moved out of the area, got some of the obligations done, moved back into the area, and at that point was violated because she didn't provide the proof that she had done that when she came back at 6 months. However, as I said, count 2, she had a full year to do that. So I don't really want to bring her back on Tuesday if it's something that they can look at. And if they're kind of an agreement here, I'd like to try to get her out today. I mean, she hasn't been in jail. This is the longest she's ever been in jail. She's got a 17-month-old she wants to try and get back to. I'm just trying to see.
I'm almost there if you just want to stay right there. Give me 1 second. One second. Judge, can we approach?
You may.
File. It does appear that there was more time for her to complete these obligations. Based on a quick review, the state's going to go ahead and dismiss this VOP at this time.
Very good. Court will dismiss the VOP, and so you need to reconnect with your probation officer.
Yes, sir.
So you can kind of figure out how to get these things
Have
done.
the JCS stuff up here.
And
I was explaining to Ms. Klosterman, she technically has roughly about 90 days, so she needs to get started on everything as soon as she gets out. The court security is going to provide her with the contact info. Second you get out, you need to make that phone call, okay?
I would put on the record that I don't think she was necessarily VOP'd prematurely because she's supposed to be giving weekly proof of her AA and A meetings to the court, and it did say that she has been failing to do that, so I wouldn't say that this was premature. However, at this time, the state's going to continue with the action that I described.
Thank you, Your Honor.
Bless you. Thank you. Thank you so much.
And I think that's all I have before the court this morning, although I do have the pre-trial detention hearing at 12:30.
Yes. We have one of the, Mr. Roach came, apparently was in another courtroom. Mr. Roach, can you come forward, sir? Who on the state is handling that one?
That's mine, Judge.
Okay, but we issued a capias, so let's see here. So this is case number 2020 CF 2883, Mr. Roach. This is a violation, well, that's actually an evidentiary, so there's already been why didn't we appoint you an attorney last time?
He told me to go talk to my lawyer to see if I needed to have him come with me to pay for it, to see if accepting the violation would cancel me from getting the early termination down the road, or would it, hurt me in any way, because I failed a drug test, but I got a medical card, so I don't my lawyer kind of said it was at you guys' discretion, because technically it can't really hurt me because I have a medical card, but I don't know.
Okay. I'm not following.
Judge, his violation is based on the fact that he tested positive for marijuana in his system.
Are you saying yes, it's a problem?
I have not seen that card, Judge.
I don't get it out my car if you need me to.
How do we want to handle this?
Judge, the state's offer in this case is to modify to include a substance abuse evaluation and any recommended follow-up treatment. That's the offer in this case. If he wants to step to the side and show me that medical marijuana card and I can look at the dates, it might impact the case, it might not. But that's the state's offer right now if he wants to resolve the case.
What do you want to do? You want to go try and find go show the
It's in my wallet. I can go get it if you want to.
Okay. Go ahead and go get it, come back, and we'll figure out where we're going.
Thank you, Judge.
We'll withdraw the cases next time, however. Okay. Ms. Farkas, you want to do your?
Sure, Your Honor, that's fine.
Okay. Your first one is James Calvert.
I've got the females first.
Okay, fine.
Keisha Carter. Carter.
Did you announce the case, Ms. Farkas?
Your Honor, this is Keisha Carter, 2022 CF 2723. She's here on a violation of probation. We'd like to enter a denial and request a continuance so that Ms. Carter and I can discuss the case. I can discuss it with the state.
Enter a denial and we'll come back on 3/14, March 14th at 9 a.m. without subpoenas.
Thank you.
Next is Clampett.
Your Honor, this is Jamie Clampett, 2021 CF 3234. I spoke with Ms. Clampett and with the state attorney, and the offer is, Ms. Clampett is going to accept it. It's admit the VOP.
You don't have to give me the terms. Do we have it in writing?
Yes. I need to have my client sign it and the state as well.
You have an extra copy? That's the only copy?
It is my only copy. I apologize.
I'll let you.
Okay. Okay.
So go ahead and, have they signed it? Okay. Then when it's signed, you can announce it.
Okay, thank you, Your Honor. Okay. Ms. Clampett is admitting the VOP, will pay a $50 VOP fee, $50 cost of prosecution, 60 days, Okaloosa County Jail, credit for time served, revoke and terminate probation.
Okay. Thank you. The state's in agreement.
Yes, Your Honor, that is the state's agreement.
Ms. Clampett, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So, Ms. Clampett, you heard your attorney state the terms of your plea agreement. I see those same terms are in writing on your written plea agreement that you've signed. Have you read through this closely?
Yes, sir.
And you understand that by entering into this plea agreement here today, this will be a final resolution of your, actually, of the violation and of your probation, because you're going to revoke and terminate the probation after you complete the 60 days. I don't know how many days. We don't calculate the number of days. But after you complete the county time, then you'll be finished. Let's see, how many days are we allowing her some days, usually at least 6 months to pay those fees? You want to put that on there?
Yes, thank you.
So you've got some fees that are a part of this agreement.
Yes, sir.
You'll have 6 months after you get out of jail to pay those. And that'll keep you from basically them going after driver's license and all that, which had all the problems when that happened.
Yes, sir.
So you got to pay it in there. If not, you're not going to get picked up or anything. It'll just go to a lien, but it would affect your, potentially affect your driver's license. You don't want that.
Thank you, sir.
So you understand that this is a final adjudication of your case?
Yes, sir.
You're waiving the right to go to a trial.
Yes, sir.
All this. Believe this is in your best interest?
Yes, sir.
Based upon that, the court will accept your plea agreement. There'll be an admission of the violation of probation. Was there a previous adjudication? You say adjudicate guilt. Is that new?
No, I'm sorry, that was probably my mistake in.
Okay, so for today, we're admitting the VOP.
Yes.
It's previously an admission of guilt, so.
Yes, Your Honor, this is pled to misdemeanors, Your Honor, so there was an adjudication of guilt for misdemeanor charges.
That's fine. It doesn't. So, then you have some fees, $50 cost of VOP and the prosecution. You'll have 6 months to pay. You'll get 60 days. Court sentencing you to 60 days in the county jail. You will get credit for time served, but you will also revoke and terminate probation. So you're done with probation when you get out.
Yes, sir.
Okay. Question?
Yes, sir.
Okay. Good luck.
All right, thank you.
Fraser. Fraser.
Your Honor, if I could approach briefly. I'm not supposed to.
What's the last name?
Oh, Fraser. It's not actually about this case specifically.
Is that your case?
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
The Cottage Formalware, located at 648 North Wilson Street, has all your...
It's a good time to take a morning break. We're going to take about a mid-morning break, so we'll take about 10 or 15 minutes, and then we'll come up.
All rise, please. Court is in recess.